Well, welcome today, everybody. I'm Jennifer Renney Butland, and I am a qualified solicitor. I've been qualified now for 31 years, and I started my own company in 2006. So we are Renney Co solicitors. We're a small team of niche employment lawyers. We're currently based in just off the bottom of Queen Square, although we are actually looking at new offices at the moment, so we're hoping to expand. And I'll come on to that later, because if anybody knows of any junior solicitors who might be interested in a job, we are looking. I seem to have lost. Oh, there we are. So I'm the owner of the business, established in 2006. My senior assistant is Anya Patel, who I think you may have met before. She's a very experienced litigator and negotiator, and that's what we spend a lot of our time doing. In fact, we spend a lot of our time advising and negotiating. We try to keep out of the tribunals because nobody wants to incur the expense and the time and the stress of being in the tribunal, but we do actually represent people in tribunals as well. So who are our clients? Well, they come basically into three separate categories. There are individual employees, and there are also employers, and also people who are self-employed. And it may sound, well, why did people who are self-employed, why do they need advice? But they quite frequently come to us for advice about restrictive covenants and how they're affected by restrictions in their contracts. And quite often it's a case of ascertaining whether somebody is an employee or whether they're actually self-employed, because it isn't always clear. And as any accountant will know, there are lots of different criteria to ascertain whether you're an employee or somebody who's self-employed. So we give advice on status as well. So turning to individuals, we act for all types of people. We get from right down the bottom right up to the top. So we might be looking at, somebody who's lost their job, they're a part-time cleaner, they're obviously, they weren't earning very much in the first place. Yes, that is Theresa May. Yes, that's not a very big one there, is it? So, we help everybody. And, we do give good value for money, and we do take into account if we can see that people are pretty poor. We do give them quite a few concessions in terms of the fees, because we like to represent everybody. If we can see that they've been hard done to and that there's been unfairness or discrimination or whatever, then we like to see that they're represented and we can negotiate a deal for them. We also deal with, the sort of the idiots of the office who think they're entitled to, they're being sacked. They want some sort of, they want to know where they stand. So we'll tell people, look, this is the situation, this is where you stand. Either you have or you haven't got a case, and give them some guidance as to where they take it from here. And we do deal with a lot of high-earning individuals who they may be directors of their business, they may be just senior management. And for whatever reason, their face no longer fits, and they're looking for an exit strategy and some help with negotiating an exit package. So frequently, we're looking at shareholding and senior directors. What do we do for individuals? Well, everything, basically. So if you're an employee, you might come to us when you've already, when you're in the middle of a dispute, there's something happening at work that's causing you a lot of stress. You may be off sick. Because of stress, you may be depressed because there are things happening in your life and at work which aren't going your way. So we will advise on workplace disputes, and we will advise on grievances. We will advise people if there's a grievance situation here, how they can voice that grievance and the procedures that they need to follow. And we can either deal with it for them directly, or we can be in the background and give them guidance. So that is, we play it by ear. We can also help people with disciplinary action. If somebody's being disciplined, they may feel it's unfair. We will help them with that. We'll guide them either directly, we'll challenge directly the employer, or we'll act in the background and give them guidance as to how to enhance their position and how to deal with their situation. And obviously we get people coming to us who've been dismissed. They want to know whether it's an unfair dismissal, they want to know whether there's discrimination. So we advise people on those scenarios. If you are advising anybody who 5 minutes. You are advising people who are in that situation. There are very strict deadlines. We've got 3 months to act. So they do have to act swiftly, and the tribunals enforce those time limits very rigidly. Restrictive covenants, employees often come to us. They want to know, can I go and do X, Y, and Z? I'm leaving the company, and we can help them with that. So whatever the scenario, we negotiate the best outcome for the individual. We also act for businesses and employers. And as I've mentioned before, we can ascertain whether there's a self-employed status or whether there's an employee status. And we recognise that the staff are the most important part of the business in many cases. You know, staff are the valuable asset. So we will help businesses to run their business and to deal with their staff and manage their staff. We help them to apply fair procedures, so they know what the procedures are, in order to manage staff, and if necessary, to manage staff out, because some staff can be quite disruptive and a very negative impact on the workplace, and you know, we will help to manage those people out of the business if appropriate. So we will actually run grievances and chair grievances and disciplinary hearings and appeals ourselves for the business. So if you've got a small business, they may not have their own HR person, their directors are busy, they don't know how to handle all of this. So we will swoop in and we will chair the meetings for them. We will hear the grievances and chair the disciplinary proceedings and guide the business as to what decisions they should make and what the outcome should be. And the advantage that we have over other HR people is that we're often at the cutting edge of the tribunal proceedings, so we see from our own experience what's happening there. But also we have what's called legal professional privilege, and that means that nobody can access our files, nobody can access the advice that we've given that business. Whereas if you if you have your own HR person or if you instruct an HR personnel, those documents that HR advisor has prepared on behalf of the business can be subject to what we call disclosure, and the other side, if there are proceedings, they're entitled to see them. All right, so that's always an additional benefit if you come for proper legal advice. We do offer a retainer service, and if any of our clients are interested in that, it tends to be the clients who come back to us regularly and who are constantly asking if there's another problem that they meet. So we put them on a retainer service. The benefit is that they can spread the cost over the year, and they've got the continuity of the service and the security that they can just pick up the phone, and they've got people at the other end who know what they're talking about, and because we know what's been happening in the past in their business. So just a few examples, which are always a little bit more interesting than the dry stuff. As far as the employees, I'm just going to give you a couple of examples of employee cases that we've dealt with recently. So one case we dealt with this year was a large supermarket, was the employer, and the employee came to us. Their line manager had clearly taken a dislike to them for whatever reason. They had less than 2 years service, which meant that they couldn't actually bring a claim for unfair dismissal on the face of it, and they'd been sacked. Now, when we probed a little bit further, and this is in a complimentary conversation on the telephone, which we normally offer our clients, prospective clients, it transpired that they had a poor attendance record, and the reason for the poor attendance record, the intermittent absences, was because of depression. And this was a long-standing condition, illness that the employee had suffered, which in this particular case amounted to a disability under the Equality Act. So in that particular case, the absences for depression, that was the cause of the absences. There'd been a failure to make reasonable adjustments in the workplace, and there'd been a detriment, which was the dismissal, and the other action, and we managed to negotiate an exit package for that particular person. They got 6 months' pay plus £5,000 for injury to feelings because of the disability. All right, so those are the sort of things we can achieve for employees where there's been discrimination. Another case we dealt with recently, there was a female employee. She was working in a finance company. I won't mention the name, obviously. She was the subject to a redundancy consultation process. And I don't know if anybody's familiar with redundancy processes, but what happens is quite often that the employer, they'll take a number of people and they'll say, well, we've got 20 staff, we're going to have to whittle it down to 10. So we go through a points system, and they have a selection criteria. And one of the selection criteria was the individual's flexibility. Okay. And in this particular case, the flexibility, she was marked really low for flexibility. And the reason she wasn't flexible, she couldn't work extra hours, is because she had childcare commitments and was a single mum. And that actually amounts to discrimination. So when you probe and you get the details, actually, we could see that there was a case there for discrimination. In that particular case, she still wanted to leave. She felt she'd been treated shabbily, and we negotiated an exit package for her. And just quickly turning to a couple of examples for employers. There we are. I'm just imagining Jason Statham as an employer. Oh, no, he's an employee. He's... I just thought we've got to have Jason Statham in there somewhere. On this particular occasion, the employer, unfortunately, had already sacked their member of staff when they came to us, which was extremely unfortunate, but it was a fait accompli. They hadn't followed any procedures. What had happened was she'd been rude. She'd been actually very rude. And the management said, well, we're not putting up with that, just sack her. So she was sacked on the spot and she was packed. Oh, right, you're out. So we had to, so obviously no fair procedures there. And on the face of it, an automatic unfair dismissal. So we managed the situation thereafter, and we said, okay, well, let's lodge it. We'll accord her the right of appeal against the dismissal. So we're giving her an opportunity to appeal and to put forward her grounds of appeal. So it's a damage limitation exercise in this situation. She did appeal, but she decided not to attend the appeal hearing, and the appeal was not upheld. All right, so because it was felt that there were valid grounds. The only part of the appeal that was upheld was the procedural irregularity. But the argument being that actually we had sufficient grounds, even if we'd gone through a correct process, you still would have been dismissed because of your rudeness and your failure to carry out a reasonable management instruction. So we minimised the risk of her, and we did settle it. In fact, she was paid £500 because, you know, it's not worth the risk, and she settled at that. So that was a good outcome for the employer because there was an automatic unfair dismissal. So we do things like that as well. How am I doing for time? I've run out of time, okay. Well, I've got a few more examples. I'm not going to give you any more examples then. We've got lots of examples of the kinds of work that we can do for employers and employees. We always give a complimentary discussion at the beginning of a conversation. People ring us up and we get to the bottom of what they want. We tell them how much it's going to cost. We tell them what our hourly rate is. We give them an idea of how much we think it's likely to cost to get through the first stage. So we're very transparent about our costs. I know people are always very worried about legal fees, but we're very transparent. We're very reasonably priced as well, very competitive, and we do offer that niche service. So we are specialists in our field. We're about to move offices, and I'm hoping that if anybody has any contacts in the legal field, and you do know any junior solicitors, if it's litigation generally, they don't have to specifically have employment law experience. I'd be really, really interested in talking to them. So that's Renney Co solicitors. If anybody has any questions afterwards, please let me know.